Hi, I'm Emily and I am here with Maya Murphy's attorney, H. Daniel Murphy. Attorney Murphy practices at Maya Murphy's law offices in both New York and Connecticut. My question today for Attorney Murphy is, does alimony end if my ex remarries or lives with someone else?
So that's an interesting question. It depends greatly on what the initial alimony order is. First off, agreements and judgments are the same thing. So if you reach an agreement with your ex-spouse about what alimony is going to be paid and how that alimony is going to end, or how the term of that alimony is going to end, that agreement becomes a court order. And that's the same as if you went to trial and you had a judge issue an order that gave you exactly those obligations. Alimony orders can be written all different ways in Connecticut. Sometimes they're time limited for a term or a fixed amount of time. Sometimes they're not time limited. Sometimes alimony awards on a very long marriage, for example, might be lifetime alimony awards. In other words, they're modifiable at some point in time if someone stops working or retires, but there is no end date to the alimony. Sometimes, in very rare circumstances, alimony awards can be a lump sum award, although this is typically done by agreement. The question is whether remarriage or living with someone else, cohabitation, terminates alimony. And alimony awards that are time limited typically terminate upon the death of either party, although alimony may also be secured by life insurance, which is sort of a different issue. They can also be terminated, would also be terminated on the remarriage of the recipient or the end of the specified term, the end date. While remarriage will cut off alimony, typically cohabitation, living with someone else under circumstances in which you're not married, does not have the same legal effect, at least not automatically. Divorce lawyers refer here in Connecticut to the cohabitation statute, although the word cohabitation is not actually used in the statute itself. And the law says that where there's an award of periodic alimony, that's time-limited alimony that's paid either in monthly installments or quarterly or annual installments, where periodic alimony was ordered, a judge in Connecticut, in the judge's discretion and after a hearing, may modify, suspend, reduce, or terminate the payments of periodic alimony upon two showings. One, that the party receiving the alimony is living with another person, and two, that the arrangement is one, the living arrangement is one that the court finds should result in either the modification, suspension, or termination of alimony because the living arrangements change the financial needs of that party receiving the alimony. That's an important piece. So the statute also allows for the parties to describe and agree to circumstances contractually within their divorce agreement under which alimony would also be modified, suspended, reduced, or terminated. In other words, the parties could either go with the statute as it is written, or they could come up with some other definition of what cohabitation means, or come up with some other circumstance under which alimony should be terminated or suspended or modified. The statute originally was written to address the concern that an alimony recipient would never remarry during the alimony term. There would be no incentive to do that, and would instead just live with another person in order to maintain the alimony award, while effectively they're holding themselves out as husband and wife, but not married. So first, in order to prevail on a motion for either termination or suspension or modification of an alimony order on the basis of cohabitation, you need evidence that that the recipient of the alimony is living with another person. And that typically means more than a couple of nights per week. And there are many ways to determine that, and the court will look to all kinds of evidence that's offered to show that two people are in fact living together and acting as a family unit. The second prong of that test, the change in the living circumstances as it relates to finances, is often more problematic. Remember, you have to show that the financial needs of the recipient have been altered. Now that can mean all kinds of things as well. Sometimes it's not as simple as a person that's now living with the alimony recipient is paying rent to live there. That's very straightforward. Sometimes it's not that simple. Maybe they're paying a utility bill. Maybe it's the size of the house that they live in that is somehow different because of the living circumstances. Or maybe childcare costs, for example, could change because the person is helping with childcare in exchange for living in the house. And there might be some agreement, whether written or unwritten, in that regard. This can be very fact specific. And there's really no limit to the creativity of the parties in these types of cases, or the creativity of very good trial lawyers in negotiating and litigating. Even if both of those prongs are proven, and this is important, a judge in Connecticut is not mandated to make any change to the alimony order, but again, will exercise very broad discretion in finding what is fair and equitable in a given case. Even if both matters are proven, that someone is living with the alimony recipient and that the financial needs have been altered. In other words, the judge still doesn't have to necessarily act, but he or she can take all the facts into consideration in deciding whether to terminate alimony, whether to suspend it, whether to modify it to some degree, and how that would be most appropriate. If you have an alimony obligation and there is a situation involving cohabitation, you should certainly consult with an experienced family law attorney about your rights and options in that particular case.
Attorney Murphy is available 24/7 and can be reached by calling 203-221-3100. You can also email Attorney Murphy at hdmurphy@mayalaw.com, and please visit mayalaw.com for more information.